Why don't we get going for those that got on right away at 8 here? So I'll just say good morning to everybody and welcome to this month's HR briefing with Von Briesen and Roper. Topic today is FMLA and ADA challenges for employers in the COVID environment. Hopefully that environment goes away pretty soon, and I think we're certainly headed in a positive direction. As always, we have with us the much esteemed staff from attorneys from Von Briesen, notably Jim Macy. Did I get that right, Jim Macy?
You did.
I pronounced that right? and he has a new face with him today, and I think I'll have Jim introduce Tony and then have him take it away. Just to remind everybody, if you have questions, use the Q&A tab, and I think Tony and Jim will be monitoring those and answering those as we go along. We're recording this, so it'll be up on our website later this afternoon for your viewing pleasure later. So with that, I'm going to throw it over to Jim, and you can take it away.
Great. Well, thanks, John. Certainly a pleasure to be here again this morning and back within our breakfast briefing series. As John said, my name is Jim Macy with Von Briesen, and along with me is Tony Wakowitz, one of my partners here at the law firm within the labor section, the employment section of our firm. Tony is a little bit new, but not so new as far as that goes with us. Tony and I had worked together a few years past, maybe 6 years ago or so, before he did some internal in-house work at one of the places, but has returned with us, and it's good to have you back again, and as we're working on the different things and the different challenges that we get. So
yeah, great to be here.
So today, it's a program we do every couple of years, but it's really been different, is the things that we've been working on in the overlay of the COVID aspects. So we take those leave issues, those FMLA issues, the ADA issues, and they're just put into a different kind of environment. It's just as raised different challenges and issues interrelated to the other things that we have. So this is our FMLA ADA presentation that we do, but again, it's been modified, updated. We always do that, but I mean really modified a little bit as it relates to the COVID pieces to that. So yeah. With that a little bit, I can tell you from an agenda standpoint, we'll talk about the COVID overlay a little bit more and some of the bigger issues we're seeing with that, and why that's impacting these other aspects. We'll come back to the FMLA pieces, but we'll expand that. I know that not everybody is covered by the FMLA, but almost everybody has leave policies. So we'll talk about the interrelationship between COVID and then whether you have FMLA or whether or not you have other leave policies that you implement. And then we'll talk about the ADA issues that go with those kind of things. And as John Casper had said, to the degree people have, we'll try to monitor that as we go through in terms of the chat and the different question pieces of things and go from there. So the other thing we were talking about just before we came online here is we're working on about 2 years from something that was going to be maybe a 2-week experiment during the COVID time period, but 2 years of the Zoom presentations. We're talking that the breakfast briefing series was the first Zoom presentation that the chamber had done back at the time, and here we are today. So what's going on with what we were then, not knowing where we were all going to be heading, and then all of the dynamics that have gone with these kind of things. So as you all know, there have been these on and off regulations. There's been this on and off guidance. There's been confusion. Every state has different mandates in regards to masks and other pieces to those kind of things. We've had quite a bit of litigation over who has the right to do this, whether the governor does, whether a city council or village board does. And it's been really difficult. And as we talked about in a prior program, the recruiting aspect on top of all of this has made it really, really difficult. So the question for today is the ice breaking? Are we finally seeing some changes for whatever reason? Is it that the science is so much better now and the technology is better that we're more comfortable opening things up? Maybe. Is it that the impact of the disease itself is lessening, that the impact on hospitals is less? Maybe. Is it that the political pressures are to such a degree that people have said, we can't stand it anymore? And if you're a trucker up in Ottawa, you might know what I'm talking about. Is that we don't care what the science said. I'm not saying what's right or wrong, Tony. You know, it is what it is. But is that what you're seeing as well? And I mean, other pieces to that.
Right, exactly. And I think just more on the political aspect. I mean, just seeing the dispute on the vaccine mandate issue and the back and forth on that and going up to the Supreme Court, and then that kind of coming away as well. And then you just see these continuing withdrawals, in a sense, of whether it be mask issues or in-person meetings, things of that nature. You know, even just looking at the news this morning, you see whether it's districts or municipalities that are kind of pulling back on those sorts of issues, and so just kind of that trend continuing.
Certainly the states, as you can see over the last couple of weeks, have reduced the mask mandates or eliminated the mask mandates. Also, you know, news-wise, the university system, or UWO, is going to take away the mask mandate, I think within a week or so here, but UW-Madison and the system's looking at a couple of weeks as we head into the spring break time period. That's huge in terms of where others were a little more strict with the mandates, sort of stepping back from that. So is there a breaking of the ice? There isn't any question, no matter what the rationale is for that. That's clearly where this trend is. That's masks. That might the last thing is the CDC yesterday said we will have new guidance out really soon. I was checking this morning. It wasn't soon enough that we could report on it, but as you know, we keep track of that stuff daily, and we'll send out articles, update our website and others as soon as that hits. The predictions clearly are that they're going to reduce the guidance and the mandates and some of the restrictions. They have to. Regardless of what rationale gets used, it's going to happen. So what might be predicted with that? Again, merely a prediction. But are you going to see a lessening of the social distancing pieces? Probably. Are you going to see a reduction in the restrictions regarding masks? Absolutely. I mean, that's a pretty safe bet. Are you going to see other things having, and here's the bigger impacts. The quarantine and the isolation rules have been, and we've said this a million times, but they've been guidance and not necessarily the rule of law. It's a balance of liability issues. Watch and see what happens, and we're really paying close attention to see what happens with those kind of restrictions. Are we going to see big ice breaking in regards to those that are covered by the vaccine mandates? I'm not as optimistic that we're going to see that yet. Clearly, the court cases continue and the pressures are still on. But I don't know. You have a feel for that, or what do you think, Tony?
Yeah, it's the other thing I just thinking about, kind of as the ice breaks, so to speak, too, and just kind of on whether it's the masking, the vaccine, and just kind of tying back to the leave aspect. I mean, I know, just thinking about places that with the FFCRA, you know, expiring, but some places also have extended that as well. And then, you know, as the quarantine, distancing, and all those kind of requirements, and that the guidance kind of changes from the CDC, you know, there's going to be less pressure on places also maybe that have extended the FFCRA kind of leave requirements, and then kind of what to do with that, and kind of going back to the traditional leave kind of issues, I think, which dovetails what we're going to talk about more today.
And that's going to raise some interesting points, because as we put some of those in place, to what degree did we leave that open enough to say that we could stop this at some point? And if you're going to stop that, how is that going to impact? Which comes to the slide that we have up in terms of, the leave culture has clearly changed over the last 2 years. We hear this almost on a daily basis from folks like you online today, where the aspect of some paid time off or some sick leave for those that have that kind of concept has broadened a lot, and we've loosened our view of those over that it might be COVID related. And we weren't going to take on the COVID issue because of the liabilities, the unknown, the scares that go with all of that. So our culture has changed. So we've got to reevaluate our cultures, each of you, in terms of your independent employment settings as to what is your culture as the symptoms and the ease that we've done with medical documentation and asking for those kind of things, or asking to, close contact. Are we going to be as forgiving about that? Probably not. And as those restrictions roll back, the point is the cultures have changed and perspectives have changed, and we're going to have to reevaluate that and then pull that back in a way that's not creating liability or creating fights that we really don't have. So now's the time to be anticipating that, and I know that a lot of you have been doing that little by little. There's clearly a mentality of I want to work at home, and as we talk about, and we will, what's the requirements legally of us giving that, where have the fights kind of been, that's clearly been rolled back as far as that goes. It's also, when we talk about it every program, the different generations are different. The younger generation clearly wants more time off. This law opened that gate further. Some of it's good, that we tried things we would have never probably tried before, and actually it works to do some work at home things and other stuff. Some of you have called us to say you've had people that we've said, we need you to come back to work, and they said, if I need to work at work, I'm looking for another job. There clearly are those kind of scenarios. So it is different. It is different as we go through some of those kind of things. If I talk about what's kind of going on in the litigation, Tony and I didn't bring it in, but there's keeping track of the different COVID cases in the different areas. There's a book of about this thick that just gives us a little synopsis of each of the cases across the country. It's incredible the amount of things that have happened in regards to this, but we'll talk just about a couple of them as we go through some of this, relating to the kind of things that we're talking about. One's the Thornberry case that was going on, and this was a case where an employee didn't want to come to work because, in their view, and go back a couple of years, people were really, really nervous about this stuff, and it's too unsafe because of COVID. They were given a certain time to come back and said, if you're not back, we're going to consider that you are resigned, and eventually terminated that person. Well, they sued, and that was during the time of FERCRA and the FMLA aspect of things. And the court said no, there wasn't a sufficient basis, at least, and it's always fact specific, but there wasn't enough basis in that case distinguishing behind the reasons tied to those leaves. And as Tony said, if you continued them, you still have the obligations that go with those kind of things. There wasn't enough time. The takeaway from a case like this, like I say, they're fact specific, but you want to go to your business reasons for coming back to work, and you want to separate it from the requirements of these two leaves, but set those aside if you don't have them, from anything that has to do with a disability or a relationship to FMLA, if you have that. And your business reasons are still going to be pretty strong. In Thornberry, that's exactly what the court said, is those are pretty strong reasons to come back to work. We need the relationship between people working together, the communication, the efficiencies, all the business reasons that go with that. There is no retaliation. There is no tie to the other leaves, and they were fine. That's an example of one of those cases. Another case, and then there's probably 50 examples like the Thornberry case across the country. Same thing with Peoples, with the clinical support options case. And this was a telework case. And again, here they had later rescinded that, even though it had gone on for a while. And again, no good deed goes unpunished, right? So the longer you continue that, the more you set a history to say, you don't need these people at work, and it can be just as efficient. That's why you were advised early as you put these together, say, we may need to rescind this. This is an interim kind of thing. This is a pandemic kind of thing. Well, now that's what we're talking about, as this kind of comes back together, people are pulling these back. Well, in this case, what we found interesting and why it's on the screen is the employee took the offense, and they went into court for a TRO trying to block the termination. Again, it's unsafe conditions. God, I had another one of these filed yesterday in terms of unsafe. You know, it's kind of phasing away, but the cases aren't necessarily. And that they had a disability and that there were other aspects of it. In this case, again, case specific, at least under the temporary restraining order burden, so a court makes an initial determination to say, is there enough to continue a lawsuit over this? And here the court said, yeah, you know what, there is enough information in this case that the employee met their initial burden to show that they may have to consider a disability and ADA analysis and the pieces to that. Case specific, they can go both ways. Let's give one other example, Tony. You know, and that's the Harris case. This comes out of Hawaii. The reason we thought this was interesting, again, it's a telework case. They're pulling this back in, and the person's terminated for failing to come back to work. They had asthma. They had other relations and other situations to say why they couldn't. But take COVID out of the picture, and how would we do this differently in any other scenario? The employee files for unemployment compensation. We've been monitoring that in Wisconsin, but here we have one out of Hawaii where at least the Hawaiian UC division said, nope, that's a quit. And again, the facts were set up by the employer enough to distinguish to say it's totally safe, there's no good business reason not to be there, they gave him plenty of warning to get back, and it was a quit. So again, depending on how we separate those cases and things like that. So back to the culture issue, and I'll talk a little bit about FMLA, and then let's talk about the other pieces, Tony. But you know, for the culture aspect, and it's always what's our impact on culture, is always distinguish this guidance that's going to be changing shortly from what your policy is. Guidance is just that. Your policy is kind of the internal law that you have, and assuming we're legal with that, that's what's critical in communicating that as to when people should be at work, where they're going to work, those kind of things. And we can't stress enough, it's communicate.
Yeah.
Thoughts?
Yeah, I couldn't agree more. I mean, that's what I saw, especially just from an in-house perspective. The more you can clearly communicate what exactly the policy is, and really with repetition, just to set those expectations. And I think it just helps from an employee perspective that they know what the expectations are, they know what the policy is, it's clear what is required, and it just kind of helps, I think, go towards that culture and setting that mentality as well. And, you know, really at the end of the day, I think the more that we do this, the more communication, the better, and that just kind of helps make sure that everyone's kind of on the same page. And so that's just kind of what I've seen is the better to communicate as much as possible on what the policy is and what the expectations are. Is just better from an understanding perspective for the employee.
I can give you, an example about that. Working on a case a couple of weeks ago. Employees, it's a discipline scenario. And the employee was scheduled to work and calls work and says, I had a close contact situation, and I was told that I was in contact with somebody for an extended period of time who's tested positive for COVID. Nothing new, you've all faced this kind of scenario. So employer properly says, well, you're going to have to quarantine under this scenario. Under our policy, it's X amount of time. You're to stay home, you're to get tested, and hopefully you're okay, and let's communicate. The employee isolates, does not come to work, so they're supposed to be at work, doesn't. They have some leave provisions that pay for this, so the employee's at home being paid until they got a little bored. And then they decided to go out and socialize a little bit at night. And then they socialized a little bit more at night. And then they ran into our friends with the red and blue lights on the way home, which brought it into the workplace, of course, because then it was news. The long and the short of all of the issues that went with that particular scenario was, well, I didn't know I was supposed to stay home, and I was okay, and I didn't have any symptoms. What's the problem here? The good news was is they did have policies. The better news was they had everybody sign off for those policies. So when we were meeting and discussing that, we presented that with the signature, and again, communicate. But if something as simple as that, I didn't know, well, there is common sense, but that aside, the policy really helps. So if we look at then the overlay altogether of these interrelation between the different leave provisions, there are a lot. And Tony and I put together the short list here, but quite frankly, it's a little bit longer. But whether you have 50 people or not, you may or may not, well, it depends on whether you're going to be covered under the FMLA. If you have one person, you're going to be covered under the Americans with Disabilities Act. We're all going to be covered under workers' compensation, another leave piece. We might have short-term disability or long-term disability. Our other medical leaves, our other leaves of absence or sick leave, and anything else that people may have created. And again, that's the short list. So when we have a leave scenario, somebody's supposed to be at work or not, whatever, or they request to be off. I need to be off. No. Then you have a sick leave day or some other reason that and it's suspect as heck because they asked to be off. The social media Facebook posts later might kind of tell you what happened with that, but it starts with being a little suspect. And it isn't just analyzing one of these laws, but we work through each of the different nuances, right, that go with the fact pattern that's presented to us. So if I look more specifically at FMLA, I'm going to broaden the discussion about this again because you're not all covered under FMLA, but let's just say this. If you adopted FMLA, and you have 30 people in your workforce, and you put that in your policies, pretty much word for word, the courts have said you are now under the restrictions of FMLA, even though you don't have enough people to be covered. Look at your policies and see what your leave is, and if you're not covered, be careful not to make yourself covered by default, by putting it in the policies. When we have it, that's why, again, clear policy processes, expectations, messaging, consistent application really makes a difference with this kind of stuff, regardless of what you created or what law it might be. Your policies, and go back and go through this checklist, is does it say what the employee is supposed to do, whether it's FMLA or your own leave policy? Does the employee call in? Does the employee need to talk to a supervisor? Is there some other forms that need to be filled out? The bottom line is, what's the employee's responsibility, and is that clear in your policies? What are their rights? Some are created by the statutes. Some are created by our own practice and history as far as that goes. And what are our rights? Can we say, you're having all these doctor's appointments in the middle of the day, you're leaving at 8 to go or taking the whole day off, we need to follow up to see if these appointments can be rescheduled at another time. That is the employer's right. And employees get that wrong sometimes, and they're a little offended to say, no, if you can do this on a Saturday instead of a work day, we will have the doctor verify this is the only time they can do it. If it has to be during the workday, is noon the only time so it wrecks the whole day? No. And the doctors would need to verify if that's the only time. And you know what? History tells us it's pretty rare that that's the only time. Point is, what are our rights, knowing those kind of things? And then our obligations, one, to follow up, be consistent, but to communicate back as to what we're granting, what we're not granting, and staying within reason.
Right.
Usually these are administrative leaves that go by the year on a yearly basis. There's a debate in terms of whether in states like Wisconsin that have a state law that goes on an annual basis, whether we can use calendar. Quite frankly, we're waiting for some updated advice that we're requesting from the Department of the Feds about that. But anyway, it might be calendar, it might be annual, but there's usually that time period. That may be FMLA, that might be how you do your vacation, it might be how you do your PTO. But you want to know who's eligible and who's not, we want to keep track of it. It's also not a bad idea to update people periodically as to where they are along with that and giving notice. Their obligations to give us notice and how much notice. The times that you get no notice at all until after the fact are rare, quite frankly. Can it happen? Sure, but realistically that's rare. And some of you know there's a 30-day request period in there if that can be done. That's pretty significant in terms of timing, but it's also pretty important that we exercise that and know our rights in that regards. Employee obligations, we talked just briefly a little bit about some of those earlier, but here they are in terms of the aspects of it. The request, designating what kind of leave it is, and having paperwork, forms that are filled out in that regards. We need to ask for more information sometimes when we're getting requests for intermittent or reduced leave to see if they even comply with that or have that ability. They're going to have a broader right to do it under state law than they're going to have under the federal law. That gives us a lot more a lot more say in intermittent leave situations. To the degree that there's a substitution of benefits, and you know that the broader aspect of this under the state law is the ability to substitute whether they really earn the benefit or not for paid leave that we get. And the other aspects of reports and obligations to report and other things like that all come into play, but it's part of the checklist that goes within the policy pieces. So what are our obligations? Well, we analyze after somebody makes the request as to whether they're eligible for that. We communicate that pursuant to our policies. We let them know what their rights are. We let them know if there's changes in policies. All of this is just positive, good communication that you need within the workforce to avoid other issues. And quite frankly, it just helps in employee relations in general. And people have a confidence in that we're being fair, that we're being transparent about those kind of things.
And just to kind of add to that communication aspect, employees by and large are not going to be, whether experienced enough, they're not going to know it. It doesn't necessarily come up frequently where they just are really familiar with how things work. And so again, that communication aspect and being clear on all these policy sorts of matters just really helps the employee kind of understand and helps with that relation aspect.
Yeah, I get it, and we can probably name names, those that are really familiar with it, know how to play it right down to the minute, but yep. That's the exception. The reality, I think, and I've had a number, we've had a number of you folks tell us, people come in and they're really nervous. They're sometimes afraid to ask for leave. It's confusing as heck. And boy, if I suggest that I need leave or I got a problem, I could get fired, and people are scared. Yeah. So to the degree we can ease that fear and put people more at ease in the comfort that it's okay, but to work with us, the better. And you and I see a lot of litigation and a lot less problems with that mentality.
And just thinking about the situation too, I mean, they're coming forward, it's usually a pretty personal matter, obviously, as it's a serious health condition, whether it's for themselves personally or a family member, consistent with the law's requirements, and some people are just very uncomfortable talking about that as well. So I think that goes to the nervousness aspect that you're just speaking about.
Yeah, and then we're nervous to say, okay, now there's an issue. We don't need to know everything about it and drawing that line. But the more we communicate, even having these programs, what can we ask, what can't we ask, the better everybody's at ease. So what can we ask along those lines? And we should, enough to know whether it's a serious illness or a medical provider verifies that it's a serious illness and qualifies. either under FMLA or separately under our policy. Do we want to know the nitty-gritty of their health condition? No, we don't want to know that. So we avoid those. And sometimes the employee wants to tell you all about it. No, we don't want to get into that aspect of things, right?
That's too much information.
Too much information, exactly. And then we consider the other, let's talk about the accommodation obligations and the different things. And again, there's the whole laundry list of the different laws that come into play with that. So we just put together a list of all the things we're thinking about when we do that. So what's your process? If you had a checklist, your HR group is they're going to have a packet. And whether it's an electronic packet, whether it's a physical packet, whether it's a folder, whatever it is, but there's usually some kind of cover communication in here. It's called the memo that outlines what the things we're talking about are. What is the leave? Who gets to do what things? What is the rights? What are the rights? What specifically is the kind of request? You know, the requests, particularly under state law, fall under other areas, whether it's medical leave or family leave, birth or adoption. We need to know those because there's so much time that gets allocated, not so much under feds, but still. If I see a problem, Tony, overall, it's not keeping track of how much time and not communicating when we think people are using time or not.
Yeah.
It's probably just good that if somebody's asking for time, is everything under FMLA? Maybe not, but you have common sense sort of thing to say this probably is. Write them and say, we're going to consider this FMLA. Well, Jim, they didn't fill out a form, they didn't do that. Maybe you don't need that. At least for starters, if it's pretty obvious that's what it is, and they'll let you know to say this isn't FMLA, this is a different kind of leave. Practical thoughts?
Yeah, that brings to mind, it's a couple of situations that I came across. I mean, just on a timing aspect, and if you think about, we have sick leave policy, and someone's sick, say, 3 days, and then you've got the 3-day requirement as far as the FMLA and the serious medical condition, and kind of the interplay with, are you sick? Does it qualify for FMLA as a serious health condition? And again, I think that communication aspect helps because what I have seen happen is sometimes the sick leave kind of gets drawn out, and then it may turn into a serious health condition, and things get kind of fuzzy. And again, that documentation and that clarity on communication just helps understand it. Are we talking about sick leave? Are we talking about FMLA? Timing-wise, how does that work together, and just kind of some of those risks that come along with that.
Mm-hmm. I'm going to quickly go through some quick slides here, Tony, but for everybody's background, as Tony just mentioned, the serious health condition and the different elements that go with it, and they're here on the screen of different things we'd analyze. If it's just our internal PTO policy, we might not have all of these conditions. The reason it's here, it's not just I got a cough or I got a cold. That's not going to make it. It's a higher burden of illness to qualify for at least the FMLA pieces. We go to the certification from a provider, again, because the employee tells me I've got something doesn't carry the day necessarily. We might accept it, but more often than not, it's the provider's certificate and our request to say it's not clear enough and we may need more, but these are the different things in this slide that go into that.
Yeah, and I think as was at least touched upon in one of the previous slides with respect to the certification, sending that out and having a job description that goes along with it or attached, that helps the healthcare provider have some context as far as responding to on the certification, rather than just kind of a generalized thing that in their mind they're just responding and it may not be responsive to the information that we would be looking for.
Mm-hmm.
That's another situation I've seen, or problem that comes up, which then may lead into issues as far as communicating with the healthcare provider for more clarity and what the process is that has to go through the employee and some other kind of risks that go along with that.
Mm-hmm. And we have a couple other slides just about, again, relevant facts, things that you just talked about in terms of, to a degree, with some of these things, all are related to just that certification. So as we can see here, I think there's even one more slide. We can make this available, this presentation clearly available to people. You don't have to write this all down now, but getting back to us within a certain time on other pieces.
Right.
So the facts are this: under a certification scenario, employee has a close contact situation, and they really want to come back to work because they don't want to burn their paid leave as far as that goes. And they don't tell the provider that they had symptoms. An employer communicates back and says, we have this return to work, but they were saying they had some pretty significant symptoms related to COVID with the close contact. And the provider says, we didn't have any information about that. We want to see this employee again, and we want to test. Employee test positive. Had the employer not followed up and asked for clarification, they returned to work, we might have had a bigger problem. But again, it's communication with the provider to the degree that we can with appropriate information. How much notice? Clearly, I talked about 30 days in some. In other scenarios, it could be 2 business days, you know, as far as that goes, depending on it. But some notice, and we don't always ask for that and just assume it. It's not. Wisconsin law, a little bit different under the notice, is reasonable and practical manner. And a reasonable practice, that's helpful, isn't it? But anyway, we do work that out in terms of that. And if it's unpaid, reasonable and practical.
The law's favorite word, reasonable, which doesn't really help give us specific direction a lot of times.
Right. A couple other quick things we'll notice, you know, calling in, I talked about that before. If they're calling in, who are you going to have in? May not be enough to say I'm just sick. It's usually not. We need a little bit more information on that so we know where it's going to fall in, what obligations, does it apply or doesn't, who gets it, and then confirming with people the information, the need to know people. Accommodations for absence, whether I need a full-time leave to be gone altogether, I need some intermittent leave, I need some reduced leave. Are we going to have a policy that says you have to be 100% before you come back? Be careful under the ADA. Tony's going to talk about that. And the obligations with that. The short answer on this, under the FMLA pieces, it's not necessarily a given. It's going to depend on your workforce, your job descriptions, your others, as to the degree we're going to accommodate some of this kind of stuff. So there is an interplay between that. My short answer is it's not a given that whatever they request, they can get. Fair enough?
Yeah.
Okay. Employees' leave options, again, as we said, and this is a little bit more in depth in terms of requesting intermittent leave. It can be different blocks of time for a single illness. Or a reduced leave is a little bit different kind of thing. It might reduce the work week or the hours per day over a period of time, the full blocks of time. They're all different aspects of what could be asked under a reduced leave.
Yeah. So, for example, that brings to mind one case that I had seen as well on the intermittent leave aspect is it's more of a traditional kind of public safety related employee that needed intermittent leave for care for their parent, one of their parents. And that was in conjunction with a sibling and also being able to provide care. So it was really a scheduling matter. So we had the public safety individual that was working, say, every third day was their schedule, and then how that fit in with when their parent needed time and assistance and leave, and as well as the sibling. So, you know, those are kind of some of the considerations that also go into and obviously create a little bit more of an administrative burden and trying to figure out a schedule, but just another situation that I've seen come up with respect to intermittent leave.
Mm-hmm. Call-in policies like we talked. Who's supposed to call? When do they call? What gets said and communicated? What gets documented? Well, all of those kind of things. It's amazing, but the quick phone call and thinking about it 2 weeks later isn't really good, and documentation really makes a difference in these kind of scenarios.
Yeah. Yep.
In terms of our expectations, absences in terms of all of this kind of stuff, but again, our policies about what are the absences, how do we keep track of absences, how do we follow up, they're difficult. I get it. I get this call, you know, we get this call a lot as I say, boy, we got an absentee problem. Let me tell you that experience tells us the best cure is to regularly meet with the frequent flyers. And if they know you're watching this, if they know and you got a calendar that says, we want to talk about every Friday, Monday here over the last, you know, it gets better, and I know it's frustrating, but it's one of those where meeting with people, communicating and talking to them regularly, and they know you're on it, is one of the best cures that you can have for that. Just one other comment before we get to this, Tony, you can pick up on that, is let's talk about some other things that may not be. The COVID close contact with no symptoms is a tough call under your policies. You got to look at that. It was covered under those 2-week federal leave laws that expired. If you continue them, you still have that obligation. But it's not it's really difficult because the guidance may say somebody can't be at work, so it's really the federal government suggesting there's a liability if there's not, but it's not covered under your paid leave. Those are difficult scenarios, but it's not a given, certainly not under the requirements of FMLA and some of the other stuff we're talking about, but that's one of the tough scenarios. The fact that somebody's daycare closed or the spouse got called into work and I'm going to stay home because of some COVID close contact or some other scenario, that generally doesn't fit under the leave policies, and that's uncomfortable discussions that have to occur. But there are a couple examples when we go back through these last 20 slides we did. Those aren't the scenarios, but they're COVID-related, more difficult situations. We'll pick up on ADA a little bit.
Sure. So we'll transition now to the Americans with Disabilities Act, and as I'm sure we're all familiar, the ADA was a law that was originally passed back in 1990, which then included a series of amendments back in 2008, as is mentioned on the screen here, which essentially really broadened the definition of what's a disability, as well as provided some more additional kind of guidance and clarity. But really what we're looking for is obviously just to help provide a better understanding and greater understanding as far as the ADA, and just kind of some abilities to help you manage these issues as it comes up. And so, as Jim has indicated, obviously the ADA has created a variety of obligations for employers, and really looking at what is defined as a disability under the ADA. And as is set forth here, we've got the variety of elements that constitute what is a disability under the ADA. And what it boils down to is a mental or physical impairment that substantially limits a major life activity. And the major bodily functions is another point that's been kind of provided greater detail in more recent years. As you are aware, I'm sure, the ADA also does require reasonable accommodations for anyone that does have a disability, and an obligation on the employer to provide those reasonable accommodations through the interactive process, as is also indicated. And so in looking at, what the ADA obligations are and who they apply to, there is that obligation by an employer to provide those accommodations to disabled individuals that are qualified. And so really what we're looking at there is the essential functions of the job, and it's important and critical to define what those essential functions are to really determine whether that individual is a qualified disabled individual, and kind of what the ADA applications are, and to ensure that the job prerequisites are met. So as I just indicated, we've got the definition of what a disability is, and kind of those three underlying areas are really the major kind of prongs or elements, so to speak, as far as meeting that definition. And really what we do have here are three different kind of requirements as far as how someone could be defined as an individual with a disability. And one, they have that direct physical mental impairment that substantially limits a major life activity. Also, it could be an individual that has a record of such an impairment. And the third one is important in the sense because it comes into the more subjective aspect. It's very broad, and this is kind of an area that really, I think, expands the definition and really provides risk, is whether the person is regarded as having such an impairment, or basically whether there's this perception that they are impaired or believe, and it doesn't necessarily matter that, objectively that they may not be. It's really a bit more of what's in the employer's mind and kind of that subjective view, and if they believe that there is that impairment.
So let me give an example of that. An employer calls and says, I got an employee that is forgetting everything. I mean, they got to write it down. I tell them to write it down, and it's getting to be almost daily. And projects that are to be done, customers to be called back. I want to send them in for a fitness for duty. Well, we just got to we regard them as having an impairment, whether they do or they don't, okay? So we've introduced ourselves into the disability world, and we may not have had to do that, as opposed to dealing with it from a discussion, not a progressive discipline aspect, but program of improvement performance aspect. The rest will percolate up without buying into it, just as an example on that.
All right, so here we have under the ADAA, which is the amendments, basically, for short. We've got what the definition is of what can qualify and constitute a physical impairment. So those are pretty extensive, certainly there. And then really in looking at the substantially limits aspect and kind of what that definition is, and really focusing on what it indicates is that the major life activity is something, when it's substantially limited, that is less than severe or significant, but certainly greater than something that's moderate. So that's another consideration in looking at the impairment. So again, a little bit more on the aspect of what substantially limits is. We've got a variety of different short-term related conditions that are kind of set out here and described, in really looking at kind of this long-term permanent aspect versus the short-term, and so that's really kind of a consideration, something that we want to take a look at on the substantially limits definition and prong. So really, in looking at it, the 6 months is kind of one of the benchmarks or a guidepost, so to speak, in looking at this kind of short-term versus long-term aspect of substantially limits. Another kind of aspect that has come up with some of the amendments aspect, and as is set forth on the screen here, is before the amendments in 2008, something that was a more episodic related matter was something that did not, in all likelihood, qualify as a disability. But after the amendments, something that's more episodic or that has flare-ups, things of that nature, it could be something that would then be defined as substantially limiting a major life activity when it's active. And so really what that does, obviously, is greatly expand the definition of what would be substantially limiting and therefore qualifying as a disability.
I think these are some of the most difficult situations we face, is the episodic situations, either under the ADA or under the FMLA. And I have a migraine, and the medical provider says, the employee may be off 3 to 5 days a month, depending on the episodes that occur. Well, that gives us no notice. That gives us no scheduling. That gives us very little follow-up in terms of, is this being abused or not? And most of the employers, of course, want to help people and accommodate. But as we apply both of the laws to that, you can see where the communication with the medical provider is going to be much more intense, let me just put it that way, and much more involved over the episodic situations under both FMLA and ADA than maybe under the other scenarios. But clearly these, if I had to, what's the most difficult, it's these, and it's since the amendments, I think, as well, too.
Yeah. All right, so again, a variety of examples here of what actually constitutes a major life activity. We've got a lot of the really routine daily activities and things that sometimes I guess we take for granted: seeing, hearing, breathing, all those sorts of matters. So really a broad variety of things are listed out here as what constitutes a major life activity. And also, again, going back to a little bit of that physical aspect and definition of physical impairments, we've got a pretty extensive list of factoring in how major bodily functions are defined as the interplay with the major life activities as well. So we've got a variety of kind of bodily systems and kind of how they operate. That's really pretty expansive here. So again, looking at a variety of examples of disabilities that may come up, certainly we've got epilepsy, high blood pressure, MS, a variety of different lists of examples here that we've come across. And so really kind of transitioning to the reasonable accommodations aspect, really looking again back to that issue on the individual's ability to perform the essential functions of the job. And really another part of that evaluation is the undue hardship aspect. And so the question becomes whether the employer is required to provide the reasonable accommodations. The undue hardship aspect is always difficult. It's the employer's burden to show that and be able to demonstrate that, and the implications that has on the business aspect. But that's generally a fairly difficult standard to achieve, but something that is out there as far as the reasonable accommodation analysis. And really, what that also is part of is this interactive process is really a process that is geared towards being able to flesh out this reasonable accommodation aspect and kind of what is and what isn't a reasonable accommodations under the circumstances, because I think as Jim touched upon earlier, it's really a case-by-case basis, a individualized, fact-specific situation that really each one has to be handled kind of on its own. They're very fact-dependent in that regard.
You know, and I noticed under your slide that you had underlined interactive process. The reality is those in the business, the lawyers in the business that represent the employees, evaluate your responses based on whether or not you know the terms. And if you as the employer use the fact that we had this interactive conference and we use again, put that in writing, you had a meeting, okay? Coming through, you had a meeting. But those in the business know that you know the ADA if you use the right terms, and that's one you gotta know and you gotta use just from a practice point. Another quick practice point about that meeting is the doctor doesn't necessarily tell you what those are, right? I mean, and maybe you're gonna get to that piece in a bit, but they can make suggestions as to what the employee does or doesn't do, but not necessarily they tell you what accommodations you're going to make, all right? But it is a meeting to get the employee's input on that. It might include some suggestions from the doctor, but anyway.
Right, yeah. And again, that meeting and that process is just very important, and that just brings to mind as well, I mean, a recent situation that I dealt with in that respect. You know, the Department of Justice, and when they get a complaint on this, is really going to focus on that aspect as well. And that's, again, where it comes into play that you're aware and you use that term and you engage in that process and you document that as well, because that's really kind of a focus area that I've seen from the Department of Justice on looking at enforcement and whether you engage in that, what exactly did that process look like, and looking back on the documentation, what transpired and how did that progress, and what discussions did you have with the employee. So again, just looking at some examples with respect to the reasonable accommodation issue, we've got a variety of different examples that are set forth here. The first one, again, also kind of brings to mind another recent situation that I've seen as well, and there was both implications from the FMLA and the ADA perspective. So we had both those issues that were ongoing, and we ran into a situation where there was that period of time where it continued and the employee used up all their 12 weeks that they're entitled to, and then, that there is an extension that may come along just with respect to, all right, we've got the FMLA issue that's kind of been dealt with, so to speak, because they've used up their leave, but then we also have additional now accommodations that we have to consider under the ADA so we don't run afoul of those requirements. So really looking at a variety of other examples, we've got changes in schedule to require whatever the condition may be and what makes sense under that certain circumstances. Are there certain job duties that can be reassigned to other individuals, and something that's not really unduly burdensome on other ones and doesn't make sense, but something that really is kind of particular to the situation and something that we're taking away certain job duties so that they can kind of continue to perform those essential functions. Sometimes it may be something like just providing them more time to be able to complete their tasks. So again, here what we've got are a variety of certain examples of unreasonable requests that have come through. And again, it goes back to when looking at reassigning those tasks, it's not something to really put this enormous burden on other employees where they have to work longer and harder, and that would make the request unreasonable. And again, that modified schedule that we kind of talked about, providing more time or a change in schedule, this factors into, again, what are the business aspects and burden that would be on the employer? Is it something that's going to create such a substantial, significant cost because of that modified schedule that's really going to create a hardship on the business and their operations?
Yeah, just the usual caution we give, Tony, when we see that first one about that it could impact other people. That's not good enough that it might impact other people, and the federal law is a little different than the state law. Colorfast is the case in Wisconsin, and they had to do an assembly line duty. And they said, if you can't, and then the person said, well, I can't do my part on the line, but I can do somebody else's part on the line. And this went through, and the state had said, nah, we think you could have accommodated that, even though it impacted other people, that they were going to be doing some different stuff. And some of it had to do with some lifting and moving and other stuff. But just the caution, don't take that too far when we say that, right? I mean, case by case, analyze the facts. State's a little tougher on us on that.
All right, so to discuss the interactive process a little bit further, what we're really talking about is a meeting directly with the employee and kind of discussing the restrictions, abilities, and ideas for accommodation, and really what seems to make sense under the circumstances in light of their condition and in light of the operations. And so sometimes that may include meeting with the supervisor as well, just to kind of get a greater understanding as far as what the impact may be and what makes sense, and how accommodations that, say, maybe someone that isn't more directly involved may not have as much of an understanding of the supervisor on operations and kind of the implications or the dominoes that may fall on certain accommodations that may be being discussed with the employee. So sometimes it may be helpful to include the supervisor. And really, it's not that you're getting into kind of the details of the condition. It's really more focused on what's the accommodation aspect and the supervisor's input on that. So we aren't having really kind of direct discussions on the underlying condition itself and things of that nature. So really, again, that part of that process is really that flow of communication, and again, being able to document that, and that you have communicated and you worked with the employee to try to come up with this accommodation, because in the event that there is some later enforcement action, we've got that documentation to really show that we've engaged in that process, and we can kind of protect the employer from that perspective.
Yeah, nothing wrong with the memo that says this is a follow-up to our meeting wherein we discuss the following, et cetera, et cetera. It's amazing how people can come out of a meeting and have totally different ideas of what they thought was decided or what was said.
Right.
And, you know, is it a little difficult to have to write that memo? Of course, but God, how many times have we seen that really save the day?
Right.
And avoided a problem, and I'm not talking just about litigation, but because of the misunderstanding and people's perceptions coming out of it. This is critical in these cases.
Yep, for sure.
It's any case, but critical in these.
Yes, definitely, and I was thinking of another example that I've seen too is even meetings, that were part of the interactive process, and then someone following up with an email directly to the employee afterwards, and just kind of a little bit of a summary and kind of a detail of what was discussed. And again, that's a document that I've seen come up later in litigation as far as, all right, well, this is what, you know, what transpired at that meeting, because obviously there gets to be disputes, and people can come out of those meetings with different understandings, as Jim had just indicated. So again, it's just that another documentation piece that helps support the position of what exactly transpired and was discussed during that meeting. So really, in looking at kind of the best practices to help with the reasonable accommodation issue, maintaining a policy, certainly that's very helpful. And again, that goes back to setting expectations, something that's out there that, you know, each employee is aware of, you know, as part of a policy, and having them acknowledge that. Also setting expectations, you know, just having a clear policy. I mean, there are places certainly that don't even have a reasonable accommodation policy itself, and then it becomes this, well, then it comes up and it's not something that's dealt with on a frequent basis, and then it's like, well, how do we handle this? And then a policy just really helps make things more clear from an administrative perspective, and then also being able to point back to helps with the documentation, sets the expectations, and helps that communication process with the employee. And then certainly analyzing and reviewing all the job descriptions and postings, and again, focusing on this question on what are the essential functions of the job.
Well, you know, if we could get you what to emphasize, but God, so many times job descriptions are just so important that, and again, the essential functions, and don't take it for granted that, oh, we got those, that we're good. And the most common thing that we're seeing with it, and throw the COVID environment into it, is the work at home aspect of it. To what degree is the ability to work and interrelate with people and communicate at work at the facility an essential function? And it's going into job descriptions as it relates to this work at home piece, and as we analyze it. Is it in everyone? Of course not. But you gotta have them, and they gotta be updated. Can't emphasize it enough.
Yeah. It's exactly the essential functions aspect. I've seen it come up time and time again. That's really kind of an important aspect to have as part of the job description. There we go. Okay. So again, just to kind of continue along with the best practices here, obviously, training for supervisors on how to recognize reasonable accommodation requests. There's always, it becomes a difficult situation, because it's not as if the employee has to use the magic words that, oh, I need a reasonable accommodation. Sometimes it just comes up in the context of what they're discussing, and it's as is indicated here, it's not clear, it's not obvious, it becomes a very questionable or wishy-washy area on kind of how to handle that and how to recognize that. And so really it's just being mindful of what they're saying, and is this something that really needs to have further discussion and be part of that interactive process.
And clearly the training for supervisors, not unlike sexual harassment or the other aspect, they gotta be trained as to keep the antennas up. When you hear certain things that are sort of heading down a certain path, they gotta be trained to pick up those keys and to know what that means, and then how to respond to that.
Yeah.
So training supervisors, key on many areas, but this is certainly another one.
Yeah, and certainly, you know, encourage supervisors, if they do have a question on if a situation comes up and they're wondering, oh, how do I handle this? Certainly encourage them to consult with and talk with HR as far as all right, this is the situation, is there something that I should do, or how should this be handled? I mean, just kind of, again, more of that communication aspect, even on the other end with HR on any assistance that may be needed under a situation in that regard. Again, just looking at more best practices, in-person meeting, as part of the interactive process. Certainly, in-person matters have been more difficult over the years, but as time has gone on and things relax and the ice breaks, as we talked about earlier, that in-person aspect is really more feasible nowadays and is really kind of a key part of the process. And as we all know, it's easier to have in-person interaction and a discussion to really engage in that process and have a free-flowing conversation. And really kind of connecting the dots, so to speak, again, on that essential functions, the request, and is there kind of a nexus and connection in that regard, and does it make sense of the requested accommodations? Do they connect with those essential functions? And then again, as we, I think, talked about earlier, if there is the need for more medical information, and to really kind of tie that in with information from the physician on what exactly makes sense under the circumstances.
So if I took the scenario I was talking about before, where somebody was forgetting lots of stuff, and I put it into these practical points here, the employee may be saying some stuff or doing some stuff, and the supervisor may pick up those cues because they're trained. And where they may not rush into, and shouldn't, to say we're going to do, send them in medically right away, the performance aspect may up to a point to say, well, maybe this is beyond just the performance thing, and it usually percolates up to that. So meetings then happen, but communications with the doctors and the medical providers. Okay, the person's really forgetting lots of stuff. How critical is that, and how is that impacting the essential functions for the job? So the doctor tells us, they got the job description, here's the things the employees can do, and here's the things they're not going to be able to do medically. And then we've got to analyze a meeting with the employee, maybe getting some input from the doctor, but talk about, okay, what could we do to help with that? Are we going to do a daily log of things that need to be done? Is the supervisor going to meet periodically? Whatever that list of accommodations is, but we're not going to excuse or ignore the essential functions. The fact that the person doesn't get the stuff done, whether that's medically or just because they're not competent to do that, we can't forgive that. So what can they do? What can't they do medically? How can we accommodate that? And if we can't get the essential functions done, then we got the tougher decisions to do, and those are always difficult. But that can happen, and has happened a couple times just under the memory loss aspect within the last 6 months on 2 cases, that there were serious medical issues. And we did have to transition people to some different jobs after doing some accommodations. And it's tough. But that's the analysis, putting a practical fact scenario into what this says here.
Certainly. And again, it's important to mention, we've talked about documentation and obviously taking notes during the meetings, but as well, the interactive process, to be interactive, has to be something that's continuous in a sense. And so it's really about, all right, we've had this initial meeting. I mean, it's not just, say, one and done. And it's something that has to continue and get feedback from the employee. Is the accommodation, or are the accommodations working? Are they not? Is it something to just, it's not just something to just do, one time, and the process does have to be continuous. Get that feedback from the employee, just, again, back to communication in that aspect, and following up with them and just checking in on how things are going. So ultimately, as we've gone through a wide variety of conditions, generally do qualify as a disability under the ADA. As we've seen from the amendments from 2008, is substantially broadened the definition and what may qualify as a disability, certainly with, again, back to the episodic nature and how that's expanded. And it's difficult, but really does expand the ability of what qualifies as a disability. And again, then that kicks in certainly a broader need to provide reasonable accommodations, and again, engage in that interactive process. And so really, it does become, and as time has gone on and conditions kind of continue to progress, it really gets to be a fairly technical aspect of kind of applying it, because we've got all these the steps that are part of the process. And does it qualify? Is it a physical or mental impairment? Does it substantially limit daily activities, major life activities? And again, then do we have to provide an accommodation? What does that accommodation look like? So it's really a pretty lengthy process of analysis, and can get very technical. And again, just to reiterate and again state, the need for documentation is very important, and just seeing that come up time and time again, that it's so helpful to have those documents when issues come up. And so looking at just to touch upon a couple of cases with respect to the ADA, we've got the Severson versus Heartland Woodcraft case, where the employee notified that, or the employer notified the employee that they'd be terminated after FMLA leave was exhausted, invited the employee to reapply then under those circumstances, and then the employee, as a result, filed a lawsuit, and ultimately the court held that the ADA is an anti-discrimination statute, not a medical leave entitlement. So just because someone files for FMLA leave does not automatically allow them to just be able to not necessarily extend things on otherwise and separately from that.
So we end with a case that kind of ties together the FMLA and the ADA. I'm out of FMLA, I need more time. I'm gonna have another surgery and I'm gonna be out another 6 months. Do you have to accommodate that now under the ADA, even though there's no FMLA? And quite frankly, as I get past that 6 months, the person may requalify for another 12 weeks of FMLA. Oh my God, Macy, this is never gonna end, right? Well, what's important in Severson, in the Seventh Circuit, which means it covers us, it covers this state, is essentially the court says, you know, if it's a couple weeks, you probably got to accommodate that, fact by fact, fact specific. If we're getting into months, then maybe you don't. And again, as Tony said, the ADA is not an extension of the FMLA, and that's an important line in that case. But it kind of ties together how these different pieces. We go back to a slide with 6, 7 laws that come into play. You call, we ask you a bunch of questions because we're covering all those bases, so we can ski you through the poles to get down the hill on this particular case.
Yeah.
So.
Yeah. All right, and just before we get to questions, just one other item that I wanted to bring up and note is something that's come up recently. There was a case last fall out in Pennsylvania that at least made it past the preliminary stage. And then there's been some updated guidance that's provided by the EEOC on whether long COVID will qualify as a disability. That's an issue that's out there. It's possible that it may. It's going to, again, be very fact-specific. At least the Pennsylvania case, they made it past the initial stage. There was a motion to dismiss that was filed very early on, but the court in that case said that there's at least been enough facts presented under the circumstances that, and again, this goes back to the regarded as aspect on whether the employer regards someone as having a disability. Time will tell in long COVID as far as whether things may qualify as a disability. So again, it kind of factors back into this short-term 6 months, whether it's transitory and minor condition. COVID certainly may be that, but long COVID certainly may not be. It may be it may last longer than 6 months, whether it's loss of taste and smell, heart conditions as well that have kind of extended for a long period of time. So just an item of note to keep an eye on, that so-called long COVID may end up qualifying as a disability. So just a point of note to watch going forward.
Okay, well, we're at our time, and in respect for everybody in regards to that, we've kind of monitored questions as we went through and tried to answer them in the course of our discussion as far as that goes. So, John Casper, we are going to turn it back to you, and once again, thank the Chamber for the opportunity to present and be with everybody again today.
Great, Jim. We did have a question that came up that related to, and I don't know if I missed it while you were talking about it, but related to employee who's required to quarantine for COVID and not being able to work, whether that individual can apply for unemployment during that time. Is that?
Yeah, I referred to a Hawaii case when we were talking about this a little bit, just to touch on that a little bit, and at least in that particular case, under the quarantine aspect of things, and I'm talking about, in that case, the facts were somebody did not have symptoms, as I understood, if I recall this right, and was told to come back to work in other aspects of things, and they denied the unemployment when the person didn't come to work and could have come to work. It's going to be fact specific. The question here that was presented was a quarantine, meaning somebody may have a medical situation required not to come back may. The state of Wisconsin, I'm not familiar, we're monitoring one case, but it hasn't worked itself in Wisconsin all the way through yet to report on. We will as soon as I get an answer on that. Generally, the state's been pretty liberal in applying unemployment comp, is what I can say. But the close contact, no symptom case is problematic and could be a quit. Okay?
Yeah.
Another question, if an employee gets COVID, can I post on social media and let everybody know who works in the office? No, we can't identify people that have COVID under the guidance that we have. We can talk that we may have had a COVID experience in the office, and we may follow up with some, at least letting people know there was an experience and there might have been a close contact, but we can't identify people with COVID.
Okay. Well, Jim and Tony, thanks again. Great program as always. A couple things before we lose some people. Next week we have a couple of workforce-related programs that are going on. It's I think our third session of our workforce strategy session with Dale Feinauer is talking about aligning corporate culture with the future workforce. That'll be on Tuesday. Next Tuesday, the 22nd at 8 o'clock. And then on Thursday, we have Wade Goodsell from WMC Foundation talking about the Wisconsin project and the Wisconsin 2035 report on their economic blueprint for what they have in mind for success in the labor force in the next 15 years. So you may want to tune into that. That's on Thursday, the 24th at 8 o'clock. Both are virtual programs. So if you want to just go on our events calendar, you can register that way. Again, thank you all for joining us. Thanks, Jim and Tony. Great program as always. And we have one scheduled next month, the third Thursday again. The topic will be coming out shortly. So be looking for that. And again, thank you all for joining us, and we will see you then.
Thanks, John. I know.
Yep.
Thanks.
Bye now.